So welcome to a session today by Fox Williams, in which we will be sharing some of our recent experiences as legal advisors to law firms on trends and challenges in partner recruitment. I'm Dan Sutherland, partner and head of the professional services group here at Fox Williams, and today I'm joined by Ed Livingstone, a senior associate in our team. So just as law firms have seen a war for associate talent with headline grabbing pay rises, from our perspective, we've seen the same also being true of partners, with firms chasing partners to expand the areas that they see as being high growth sectors, as well as partners looking to try and move on where firms are trying to manage their equity. The big difference really between the associate talent war and the partner talent war, the challenges are always greater when we are looking at partner moves for reasons we will get into.
Thanks, Dan. So to kick off, one of the main things which slows down a partner's exit is the notice period in the partnership or members agreement. Is it fair to say these are typically longer for partners than they are for employees?
Yes, very much so. I think something that really shocks incoming US law firms to the UK market is just how long those partner notice periods can be. For a UK headquartered firm, a notice period of 12 months or more for a senior equity partner would be quite typical. And that contrasts quite starkly with US law firms in the US and in the UK market as well, where there will be typically notice periods of between, say, 30 to 90 days. I think to make matters worse as well, these UK partnership agreements will often now include provisions referred to as departure lounges. That can have the effect of extending these already very long notice periods when multiple partners decide to leave at once. So the effect of a departure lounge clause is to create effectively a queue for the door, whereby the second or third partner to resign in a year may have their notice extended by, say, a further 6 months or a year, beyond what is already really quite a long notice period. So that's not to say that partners won't try to extricate themselves from long notice periods. Ed, you often deal with these issues. What can a partner do if they want to join a competitor sooner than the notice period might suggest?
Well, the short answer is not very much. There isn't really much at a partner's disposal to try and force a quick retirement in the face of a long notice period. Obviously, you can leave sooner if you have the firm's agreement to cut the notice period short, or otherwise if the firm decides to accelerate the notice period by making a payment in lieu of profit share, assuming it has the power to do so. In the employment sphere, you might sometimes see an employee trying to extricate him or herself from a long notice period by arguing that he or she has been constructively dismissed, which allows them to terminate the contract immediately and also absolves them of the restrictive covenants in the employment contract. However, in the partnership context, the principles of constructive dismissal do not apply to partners or LLP members. So in order to get an argument around constructive dismissal off the ground, you would need to argue that you were in fact an employee and merely were given incorrectly the label partner. That's difficult in really all circumstances. Obviously, if a partner has other statutory legal claims like discrimination or whistleblowing, then these might, in an unusual case, be enough to generate some leverage to force a negotiated early exit in return for a waiver of those statutory claims. I suppose the only other possible measure, and again, this is very difficult, would be to argue that the notice period, particularly if it's already been extended by a departure lounge clause in the way that Dan just mentioned, is so long that it's an unenforceable restraint of trade. But again, this would be a difficult argument to run. So really, there's not much you can do as a partner in the face of a long notice period. So Dan, if the partner is going to be held to his notice period, what usually happens during that time prior to his retirement?
Yeah, so every situation will be different. The way that firms treat retiring partners is not just a strictly logical or commercial decision. Emotion is often at play as well. But the starting point, I think, for a sort of typical partner who's resigned is that during that long notice period, it will be as much as possible business as usual. You know, the partner will continue to carry on servicing the clients and will be expected to act in the firm's best interests. They may not be invited to partners meetings anymore, but otherwise it is business as usual. Now, that's not always what happens, and maybe not always for all of the notice period. Things can change over that long period of time. And there are usually provisions in UK partnership agreements that will allow a firm to regulate the conduct of that partner during that notice period. That's something that we call garden leave, which is a bit broader than the term might suggest. It's not just that you're sending someone home, paying them to not work, but just to keep them out of the office. I think it also refers to the clauses that allow partners' conduct to be modified and controlled by management during that long notice period. But if a garden leave clause is being triggered at some point during the notice period, typically that would involve excluding the partner from the office and from access to the firm's IT systems, and of course from contacting clients and staff. And so what it does is it's the law firm paying for that partner to stay out of the market and stay away from staff that they may want to take with them. So it's quite a powerful tool, and is a way that can really damage a partner's ability to cleanly exit and transition clients and potentially staff to a new firm. Though there are other issues around that we will talk about later on. The other thing that can happen during a notice period, though it is not particularly common, is that there is usually a power to reduce the profit share of a partner under notice, either a specific power or just the general ability to modify profit shares. That does sometimes happen, but it is still, at this point at least, relatively rare. There is an expectation that partners during notice period will continue to be paid in the usual way, so they at least don't suffer in that respect. So Ed, in terms of the recruitment process for a firm looking to recruit a partner when they're looking to move elsewhere, what are some of the key pitfalls that we see?
So partners are subject to obligations of confidentiality. So obviously care should be taken around the sort of information which recruiters and lateral hire questionnaires typically ask for. So, for example, details of partner remuneration and the identities of clients, billings and other data, that should all be caught by a partner's confidentiality obligations. For law firms in particular, the SRA has shown interest in this, given that there is a clear obligation under the codes of conduct to uphold client confidentiality. That said, in practice, partners will very often take a view, even if there is a technical breach of the partnership agreement or even the regulations. For more serious confidentiality breaches, or where the partner starts competing whilst still under notice with their old firm, the old firm may, in some cases, apply for an injunction or sue for damages for breach of contract. They could also potentially claim against the new recruiting firm for conspiracy or for inducing a breach of the contract contained in the partnership or members agreement with the old firm. So this is particularly the case with team moves, i.e. where a partner seeks to move to a new firm in coordination with other partners, possibly employees as well. So Dan, from your experience, what are the specific issues arising from a team move scenario in particular?
Yeah, so team moves are clearly very attractive for firms. They can bring potentially a book of business, a ready-made book of business in a much more digestible way than say a full firm merger might achieve, and allow firms to cherry pick the best bits of another firm's practice. The unfortunate thing is that from a legal perspective at least, it's almost impossible for two or more partners to coordinate a team move to a competitor firm without being in breach of their obligations as partners in their existing firm. Usually both fiduciary and contractual obligations. So that creates a huge issue from the very outset, and really worse still, the recruiting firm can often become embroiled in team moves by being accused of inducing a breach of those team members' obligations to their partnership, or some kind of conspiracy. And I think that the other issue is that team moves are viewed very negatively and very differently by firms to the move of an individual partner. Firms are, I think, quite accepting that individual partners may have career aspirations that involve leaving, but when a team move arises, it's viewed as being potentially an existential threat to the firm. You can't take too many successful teams out of a firm without it causing a serious problem. So any kind of goodwill is either not there from the outset or evaporates quite quickly when it becomes apparent what is planned. So team moves are very attractive, but they are also very difficult to pull off. And other aspects of partner moves which affect both team moves and partners are restrictive covenants. And increasingly, we are now seeing some specific anti-team move restrictive covenants, either as an addition or an alternative to the classic non-compete clause. These anti-team move covenants, they are somewhat untested, but in our view, they could potentially be upheld and are yet another barrier to pulling off a successful team move. Sometimes the juice is still worth the squeeze, but it's not always as straightforward as perhaps you might hope. So, I mean, covenants are a big issue for any partner move, and the position in the UK is quite different to the US. Ed, do you have any thoughts you'd like to share on that area?
Yeah, so aside from the anti-team move clause that you mentioned, you'll see in almost all UK partnership and members agreements the standard suite of non-solicitation and non-dealing covenants. These could well be 12 months or more, certainly not unheard of for them to be 18 or 24 months in duration. Whilst you might think that these could be unenforceable as a restraint of trade, there is a significant degree of latitude allowed for partnerships and LLPs under English law. So, for example, the leading case, it's Bridge and Deacons, a Privy Council case from 1984, in which a 5-year non-compete obligation in Hong Kong was enforced against a partner. In addition to those non-solicits and non-dealings, we're increasingly coming across, I suppose, what you call more exotic restrictive covenants in partnership and members agreements, and being asked to draft them. So this might include sort of restrictions which not only prevent you from soliciting clients and prospective clients of the old firm, but also key referrers of work into the old firm. So in the context of a law firm, you might have an overseas law firm or an intermediary, such as an accountant or something, which just provides a steady stream of new client referrals into the old firm. So that could be a relationship which needs protection for the firm from ex-partners, perhaps even more than the client connections themselves. We also see more elaborate liquidated damages provisions as an alternative to the non-dealing restrictions which apply to clients. So these don't totally prohibit a partner who's left from advising the old firm's clients, so long as the old firm gets a cut of the fees paid over from the new firm. And lastly, on the sort of restrictive covenants outside of the usual non-solicits and non-dealings, we're seeing more provision relating to social media in particular. So you might, in a members agreement, now see particular do's and don'ts about partners notifying their LinkedIn network about their new firms, or even updating their role, because that may trigger a notification to all of their contacts, which is arguably caught by the non-solicitation of clients provision, but obviously it might not otherwise be caught. So the agreement now might make specific mention to LinkedIn and social media in particular. On top of all that, I think it's fair to say we're now seeing pure non-compete obligations coming back into fashion for some professional services firms, although in the legal sector in particular, they're still relatively rare, certainly more so than accountancy. So, Dan, given all these hurdles, it's frankly a wonder that any partner or team of partners ever manages to move to a new firm at all. So how do these moves happen despite all of the hurdles we've just discussed?
Yeah, it can sometimes seem like a miracle, but the reality is that actually most firms are willing to be grown-ups about these kinds of situations, and will not hold partners to the letter of their obligations, which if they were to do so would inhibit and do inhibit to some degree these kinds of partner moves. I think the thing that we haven't mentioned as much in our talk today is that the power and influence of the client is probably the key factor. You know, if a client wants to instruct a partner who has moved to a new firm, then really there's not that much the old firm can do when faced with that demand from a client, particularly if that client has left some work behind at the partner's old firm. And the other thing is that enforcing restrictive covenants, although you never want to be on the receiving end of that, equally prosecuting the enforcement of a restrictive covenant is expensive and risky. You know, you may get an injunction, but you may well not recover all of your cost in doing so. So there's really a business decision to be made by a firm about enforcement. Also, it can work quite poorly for a firm if they seek to enforce their covenants and they are found not to be enforceable. That then means it's almost a free-for-all for everyone left. So there is usually scope for a commercial negotiation and a discussion, and a lot of these clauses, as harsh as they are, tend to form the backdrop for a sensible discussion rather than the end of the story entirely. And I think that's just as well, because it's already hard enough not only taking the partner out of the firm, but making sure that the partner works out at that new firm, which is a whole different session. So really, to conclude, I think these are interesting times for partner recruitment, with an impending recession and difficult headwinds in the economy generally. You know, it's possible that things might slow down with partners opting to stay put rather than gamble on and move to pastures new. But equally, it's quite possible that this will be an opportunity for firms to readjust their equity, and partners will be looking to actively move. And there will be a lot of interesting questions to be asked about how client relationships and business interests can be preserved in that kind of situation. So we hope you found today's discussion useful, and we hope you join us for our next session on the legal issues affecting law firms in the UK. Thank you for joining us.